They have a staggering amount of power, influencing everything from our shopping baskets to our worldview. In the past 2 decades, a small number of huge companies have come to shape our daily lives in profound ways. For a long time, their power grew almost unchallenged. But those days appear to be over. In both the US and the EU, authorities are cracking down on big tech, holding companies to account for what they say are anti-competitive practices. To talk about what this means, I'm joined now by Bill Kovacic, former chair of the Federal Trade Commission and director of the Competition Law Centre at George Washington University. Bill, you're very welcome to the programme. First of all, I really want to put this in historical context because the pros and cons of monopolies have long been debated. In the US, we saw the breakup of Standard Oil as far back as 1911. Telecommunications company AT&T was broken up in the 1980s. And in 2001, the US government accused Microsoft of illegally monopolizing the web browser market. Based on your experience at the Federal Trade Commission, what kinds of conversations do you think are going on there when it comes to the potential dangers of having a small number of tech companies dominate the market?
I think one conversation derives a great deal of confidence from these earlier experiences that competition policy intervention will not discourage innovation, but it could help inspire additional innovation. The most recent example, the Microsoft case, is a powerful example. In the complaint that the Department of Justice filed against Apple last week, you see repeated reference by the Department of Justice to its experience in the Microsoft case. And a lesson that the Department of Justice derived from that experience is that the government's intervention in the form of restrictions on conduct matched with the European Union's intervention, which also restricted the conduct of Microsoft. But the effect of this was to open a path for the new generation of technology leaders. That includes Google, it includes Amazon, it includes Apple, it includes Facebook. That the intervention did not deprive the market of innovation, did not hamper innovation by challenging these large firms, but instead unleashed innovation and made it possible for an entirely new generation of firms to step forward. So this historical experience for competition authorities, I believe, gives them confidence that seeking to remove artificial restrictions to entry and expansion does not diminish economic performance, but it creates a new generation of possibilities. This is exactly the theme that the Department of Justice has relied upon in its new case against Apple.
But the Department of Justice does need a good argument in its favour. And if we zoom in on Apple, if we look at the US, we can see that just 2 big companies have come to dominate the smartphone software market, with Apple's iPhone and Google's Android eliminating all other competition. The Department of Justice says Apple's monopoly is illegal. But as we see here, it has a massive competitor in Android. How can Apple be called a monopoly in that context?
This will be a contentious point in the lawsuit, and you're quite right to put your finger on that. The abusive dominance case in the US depends on a showing of dominance as the foundation for the case. This legal regime is not concerned with smaller or less significant firms. And Apple is not going to accept the claim of the Department of Justice that it is dominant. It's going to point to Android devices. It's going to point to the robust competition it faces globally as proof that its market share for the moment can only be sustained through superior performance. So the presence of these other enterprises will be a subject of intense debate in the courtroom. The Department of Justice, to overcome this argument, is trying to establish that Apple has preeminence in a market that might be called high-performance smartphones. Smartphones that are decidedly more expensive than other basic devices and offer users a unique array of capabilities. I suppose the Department of Justice would acknowledge that this position, at least in principle, is contestable, but it's going to argue in the case that Apple has used a variety of techniques to forestall the emergence of Android devices as more effective competitors, to forestall the emergence of other business models where app developers write applications that enable other smartphone makers to come forward and compete effectively. But you're quite right to say that there will be no automatic assumption on the part of the court that Apple is dominant. That's going to have to be proven. And the Justice Department is saying you can prove it by reference to this high performance market.
Companies like Apple are often derogatively called gatekeepers, as if this gives them a dangerous advantage. But surely they can also play an important role in things like safeguarding customer experience and security.
The chief argument that Apple has given for the collection of restrictions that are being challenged in the Justice Department case, indeed the restrictions that are the subject of some of the provisions of the Digital Markets Act, is that the closed system that it has developed is first and foremost designed to provide additional security and privacy safeguards for its users. That the reason that it strictly polices who can operate on its platform, which developers can offer apps in its app store, that all of these restrictions are foremost concerned about the privacy and security of users. And in the abstract, that's not a foolish argument, and individual users would agree. The Justice Department in its complaint strongly suggests that this is not the real motivation for the restrictions. The Justice Department complaint asserts that when you look in detail at the internal company records that it has assembled in its investigation, those internal company records suggest that the justification about security and privacy is overstated, and that at a minimum, a considerably less restrictive set of controls would serve the purpose of user security, but would allow greater innovation. So the Justice Department is going to challenge this defense by arguing that when you look at Apple's own internal deliberations and its own assessment of the effect of and purpose for these controls, that the security of the user is not the foremost concern, or that the security of the user could be safeguarded through less restrictive alternatives.
You've mentioned the Digital Markets Act a couple of times. To what extent do you think EU and US regulators are mirroring each other in their increasingly tough stance?
The trials of abusive dominance cases have given us a unique understanding of what these companies do and why they do it. That learning, I think, is going to be fed back into the implementation of the DMA. The European Union, the European Commission will be a careful student of what happens in these lawsuits, what comes out in the courtroom. And I think they will use that to inform the way in which they implement the DMA and perhaps pursue refinements in the future. So these two strategies are complementary. The DMA is a powerful tool. I think there's still a place for the litigation of individual cases to address specific phenomena, to develop a larger foundation for policy intervention, but also to inform judgments about what the so-called ex-ante regulatory approach, which is the basis for the DMA, how that approach should be implemented and refined over time.
So the Digital Markets Act, the DMA you mentioned there, it was effectively regulating after the fact. I'm wondering to what extent regulators are looking ahead and whether there are conversations going on between the EU and the US about regulating artificial intelligence, for example.
I think there are conversations. For my own preference, they could be more intensive and more elaborate. I think there is a keen concern among EU and US regulators of not moving fast enough and as a consequence being left behind. You see, I think, in the statements by Vice President and Commissioner Vestager, statements by FTC Chair Lina Khan and DOJ Assistant Attorney General Jonathan Cantor, a feeling that in the past, the regulatory response was too slow. All of these authorities are saying that although AI has remarkable positive possibilities, it has direct and perhaps unanticipated consequences that could be harmful to the society, to the individual users affected by these systems. so that it is important in some way to get in front of the development. That's why you see, I think, so much energy being placed into what we might call market studies, that is to do investigations that identify what's taking place with these technologies. I think regulators want to be poised to intervene at an earlier stage out of concern that in the past they waited too long, and waiting too long means that the train goes by and it doesn't necessarily come back to your stop again.
Right. I want to talk about another company now, and that is TikTok. The House of Representatives wants to force the company to sell its US operations over fears that American data is being harvested by the Chinese government. What evidence do they have for this?
The evidence comes in several forms. One form that is very difficult for us to assess because we're not inside the room when it is revealed has been a series of presentations made by the U.S. Intelligence Committee to the U.S. Congress. They've been giving briefings on what they know and understand about how TikTok operates. Those presentations seem to have been very influential in the decision of the House of Representatives. I assume or infer from those presentations what the intelligence authorities are saying is that the use of TikTok has the capacity to provide the People's Republic of China with a considerable body of data about individual users in North America. I infer that that's what the presentations are, but again, all of us are at a bit of a disadvantage because we don't have access to that information. That seems to me to be the principal source of information that's guiding their decision. A subsidiary source of information is a series of reports, discussions that have taken place in the world outside the intelligence community that points to these possibilities. But I'd say the most important source of information that has inspired these legislative proposals comes from briefings they're receiving from the intelligence community.
And why is that information being kept so much under wraps?
One possibility is that the way in which the information is accumulated involves the application of sensitive intelligence gathering methods, which include the observation and surveillance of the operation of these networks from satellite and other eavesdropping methods that provide insight into what's taking place, related mechanisms that enable intelligence officials to hack into systems and observe how they work and how they perform. The operation of these systems is regarded as among the most sensitive capabilities that the intelligence community has. I would say the intelligence community in many countries have them, and they have a keen interest in making sure that external observers, notably other jurisdictions, do not know how they operate. I guess a concern that one has in the background is that there have been occasions in the past in which intelligence briefings have exaggerated a threat, have based the conclusion of a threat on intuition that's not well grounded in facts. A bit of discomfort that one has as an outside observer is that you don't know quite how sound the factual foundations for the assessments are, or how sound the conclusions being derived from that factual foundation are.
Yes, and it is hard to divorce this case from the wider geopolitical situation at the moment. From a competition perspective, though, wouldn't it actually be a bad thing to ban TikTok given its role as a major challenger to the likes of Instagram and Facebook?
If we perform exactly that exercise and we put aside the geopolitical pressures and we ask what firm might be positioned to take on the incumbent platforms, what firm might be in a good position, for example, to challenge Facebook and Google, well, that would be TikTok. An essential ingredient of a company's capacity to perform that function is to have a product, a capability that users like a great deal, that users return to frequently to use again and again, to have a community of content creators that contribute into that platform, so that as the platform grows in popularity, you have a larger body of users, a growing body of users that attracts developers and content creators. And the fact that the number of users is growing inspires content creators to provide more content. That's the collection of attributes that makes a platform popular and ultimately makes it a threat to incumbents. So if we put aside the geopolitical considerations and ask who in commerce today is well positioned to emerge independently as a platform that can contest the position of the large incumbents, that name is TikTok.
Finally, as a former regulator yourself, how hard is it to police a company whose operations are primarily digital, whose services are available all over the world and subject to different rules in different jurisdictions? The logistics for both the companies and the regulators must be very complex.
There are two major implications of that complexity. They are indeed complex. It is a fast-changing environment. It involves not simply developments inside one's own country, but across the globe. There are two implications for the regulators. One is, do you have the capability to understand what's happening? And competition regulators around the world have been changing the mix of personnel. The typical competition authority had a large body of lawyers and economists. They're wonderful people, but there's a broad recognition now that if you're going to be active in this policy domain, you need computer scientists, you need engineers, you need people specialized in analytics, you need people who've worked in that commercial community who can come into your agency and tell you what's going on. So the agency of the future, to be effective, must have a significant body of technical experts who understand the technology, understand the business models, and see the direction of travel. So it requires a fundamental makeover of what your competition authority looks like. The second implication, which you've touched upon before, is that individual jurisdictions operating in isolation cannot, I think, capably address these challenges. This requires a broader and deeper collaboration across jurisdictions, that instead of having learning take place inside of single jurisdiction, you have the benefit of learning that takes place cumulatively across jurisdictions. You have, as we said before, experiments taking place in individual countries with different forms of intervention, with different specific forms of solutions. It is an enormous benefit to the larger community that the results of those experiments are widely understood and taken on to see what works, what doesn't work, so that can inform judgments made across countries. Smaller jurisdictions that cannot afford the large regulatory infrastructure would gain a lot of benefit from learning what their larger counterparts have done, so that there are enormous advantages in deeper cooperation across jurisdictions. That cooperation doesn't happen automatically. These are proud institutions. They have great confidence in what they've done. Building the deeper relationships takes time and effort. But it's worth doing. That is a process worth carrying out. So two major implications. You have to get the right people and become smarter that way to know what you're talking about. You have to work more extensively with your counterparts outside your own borders. Otherwise, in a straight race with the technology wins, the business enterprises win, and the competition authorities, if they don't improve and continue to improve in these dimensions, remain hopelessly behind.
You've laid it out very clearly. Bill Kavatus, Director of the Competition Law Centre at George Washington University. Thank you so much.
I'm most grateful for the chance to chat today. Thank you.